A very hi to all the viewers. Now we have seen often in the news the withdrawal of the data protection bill by the central government. So today we will discuss an overall framework of the whole data from the perspective of the mains answer writing. First we would see that why data protection is a need of our. Then what is data, how information flows and how much internet has introduced into our lives, and the impact of internet on individuals' privacy. Then we would see what is personal data protection bill and its past history since independence. Then the global models and approaches of data protection across the globe, and what principles we could frame in order to build a robust data protection law for India considering the 7 principles, and then why this 2019 bill has been withdrawn by the parliament and another proposed draft had been laid for the upcoming winter session. So let's get started. The world in the 21st century witnessed a digital era and is rapidly transforming into a digital society. The digital revolution has penetrated India deep as well across all sectors of the society. As we are moving from Iron Age to the Information Age, we have seen that information is a power now. And for years since we have been using internet, we giving information to anyone who asks. We give information about ourselves on Facebook through queries, Twitters and various online companies. We give data about ourselves in every means, from health fitness to our financial data and even our biometric, hoping that our private policy that we have consented to would be kept with responsibility to the service provider. And recognizing its significance, the Government of India has emphasized the digital India in the boom of digital revolution. The digital India has further brought a data revolution in the country with nearly 450 million internet users and a growth rate of 7 to 8%. India is well on the path of becoming a digital economy next to China. Now with power comes responsibility. So with information power comes a responsibility that impacting the autonomy of an individual. In this era of digitization, our personal data seems to be flowing everywhere and it is omnipresent. This data has become a new good to data industrialization. And the reality of this digital environment today is that almost every single activity undertaken by the individual involves some sort of data transaction. Some of the largest companies in the world today are data driven. Who seeks our personal information like Facebook, Uber, Alibaba, Amazon, etc., etc. And in this environment, the internet has given birth to entirely new data industry. Those dealing with collection, the processing of data and the storage of data. So these component has finally became a critical component of the new business model. Now we will understand how this collection, the processing and the storage of data takes place. In technical terms, if we talk of this collection of data by any other entity, for example, the service provider, which we called as the fiduciary. The collection of data by any entity is called fiduciary. A data fiduciary is defined as an entity, the collecting, the processing and making decision what to do with your data. So this decision is called the processing. When we make inference out of data or when we make sense out of your personal data, this process is called processing of the data. And sometimes these entity or fiduciary, sometimes they use our data for their own business model or sometimes they outsource the information to third party. For example, Facebook might be asking or collecting our personal data. So they may take decisions what to do with that data. And sometimes they may hire other party so that our data could further be dissected some way, so that the relationship, the trust between the data principal means we, whose data has been sought or whose data has been or whose personal information has been taken, is defined as data principal. So we must know that the relationship between the data principal with that of the fiduciary has an element of trust in it that goes beyond transaction. So we give our data to any fiduciary. It is obligated to use it in a trustworthy manner. Next is the storage. Our information, when further be stored, whether within the country, which is called localization, or outside the boundary of the country, means foreign. Sometimes the fiduciary or the service providers are foreign entities or the same nationals. So it is important as to where your data has been stored, because where the data has been stored gives power to control the ownership. So as we harvest the benefits of digitization, protection of our personal information is vital, or let me say so in strict terms that it should be non-negotiable. Means when a data principal or we provide information for his or her data, the consent to provide the data, does he consent to the dissemination of the same? When our data can be put to beneficial use, the unregulated or arbitrary use of data, especially personal data, has raised concern regarding the privacy and autonomy of an individual. And this was actually the subject of the landmark judgment by the Supreme Court, which recognizes the right to privacy is a fundamental right in the Indian Constitution. Now let's see how this digitization affects autonomy of an individual, or how it impacts the individual's privacy. When we harvest the benefits, that means we have right to information, and that's how we harvest the benefit of digitization. But simultaneously, in order to protect our personal information, we have right to privacy too. So right to information versus right to privacy. When we provide information about our personal data on any online platform or any service provider, for example Facebook, Amazon, sometimes these entities process our personal data, and they sometimes outsource our data to third party who use it for their own business model and make the profiling of an individual, which then be used for targeted advertisement. For example, how many graduates in a particular city are athletics too? If Facebook provides information to any particular shoe manufacturing company, this shoe manufacturing company would then target individuals. Then this shoe manufacturing company would make a profile out of those individuals and deliver the targeted advertisement. Sometimes we have often seen that when we log in to any particular site, they sometimes often ask for our media file access or our audio access, which sometimes not only records but have a tendency our conversation, which in turns through artificial intelligence display the targeted advertisement of particular product on the online site of our screen. So this is a kind of breach of privacy of individual. Now you will say, so what? It is good for us that we are getting access to the advertisement of our product of interest. But what if I make you aware of another incidence of surveillance? Like we have recently seen in last year the parliament debate regarding the Pegasus issue. Secondly, there has been lot of news on the internet regarding the Apple Series related scandal. Apple had contractors listening to Siri recordings where they heard private conversation of involving drug deals. The Apple Siri violated the privacy of millions, says whistleblower. in which the contractor listening to the user's Siri recordings without their knowledge or consent. In Silicon Valley, company is sending a proportional of Siri's audio records. And nevertheless, there are so many news relating to when the Siri has recorded private conversation of private movements of two individuals and sending back to their headquarters. For that, Apple has been fined $1 million penalty by the US government. So can you imagine, in this era of digitization, these gadgets have encroached so much into our personal life that we simply cannot make them aloof out of ourselves. With benefits, they have brought a matter of concern to individuals' privacy and autonomy. So here a concern issue is that the privacy or the security should not be traded to digitization. So for this, the Government of India has constituted a committee of experts to study various issues relating to data protection in India and suggest a draft data protection bill. The objective is to ensure growth of the digital economy while keeping personal data of citizens secure and protected. So this will act as a foundation on which data-driven innovation and entrepreneurship can flourish in India. So let's understand the same from the government's document point of view. So first of all, I will read it to you, the Personal Data Protection Bill 2019, and then we would make a sense out of it word by word. So this is very important. We need to memorize data in a very short and in a very precise way in order to have a broad and better understanding of the aims and objective of the data protection bill. Only then we would be able to develop the concept for our mains answer writing. The bill says to provide for protection of the privacy of individual relating to their personal data, specify the flow and uses of personal data, create a relationship of trust between person and entities processing the personal data, protect the right of individual whose personal data are processed, to create a framework for organizational technical measures in process of data, laying down norms for social media intermediary, cross-border transfer, accountability of entities processing personal data, remedies for unauthorized and harmful processing, and to establish Data Protection Authority of India for the said purpose and for matters connected therewith incidental thereto. The law says that the privacy of the individual relating to the personal data should be maintained, thereby keeping the autonomy of the individual intact. And the data, as I have already told you, how data flows and how it has been processed for various authorized and unauthorized purposes, which leads to breach of privacy and the dignity of the individual. And the uses of personal data. Sometimes these data has been used by the government in policy making purpose, and sometimes state or non-state actors to target individual. Sometimes there has been into the news that as to how many peoples are pro particular political party. So on the basis of political decisions has been taken. So for what purpose the data has been used, the information should be provided to the individual, and without his or her consent the data should not be used. If we talk of the European Union model with that of right to privacy, it should include right to forgotten, which state that data should be available on any internet platform till the time it is authorized to do so. When the purpose has been done, and if the individual whose information has been put on online, it could be erased when the individual have asked to do so. For example, if a person has been accused and the trial is going on, the individual set free with the declaration that individual have proved to be innocent, his or her data which has been available in the media defaming his individuality, it could be taken back or it could be erased on all online platforms. So this is widely implemented in European Union, this right to forgotten. So this create a relationship of trust between persons and entity processing the personal data. Now this needs to be understood in a very broad perspective. This statement is of utmost important. The trust between the person and the entity processing the personal data. Now there is a power asymmetry between the service provider and the user. The power asymmetry comes largely because the user is unable to forecast the harm that are inflictable by the service provider by violating its privacy. So it's all a game of personal asymmetry and power asymmetry. Or we can say that between the service provider who collects our information, whether it's a government or a non-government entity. For instance, personal data collects without limitation of purpose, without telling the user as to which purpose they have been collecting. So every service provider seems to be very hungry of your information. The reason being that with personal data comes power superiority. As I have earlier explained that information is power in this 21st century. So with this power superiority, the user would then be able to map combining this different database and make sense out of the people. So therefore, the bill implies that the relationship with that of the data principal to that of the data fiduciary has and should be an element of trust in it that goes beyond transactions. For example, if we give our data to Facebook as a fiduciary, it is obligated to use it in a trustworthy manner. So this trustworthy is the soul, and it should be the soul of this data protection bill. So main soul of this data protection bill is the trustworthy. It could be with anyone between the government entity or the non-government, and here the government entity should be the highest accountable authority to develop or to maintain trust among its citizens. The next it says, protect the right of the individual whose personal data are processed, right to privacy. To create a framework for organization and technical measures in processing of data, laying down norms for social media intermediaries, cross-border transfer. We would see this leads to data localization as to where our data is stored. That has also played an important role because, as I have already told you, that this gives the cross-border transformation, because if India does not have control over the data fiduciary or the place where it has been, where the data has been stored, will have the ability to control the ownership over our data. Sometimes it leads to misinformation or sometimes it leads to intellectual property rights. So this has been a hardly contested debate among many stakeholders claiming that about the location. Sometimes the data may stored locally, but who knows, it has been processed outside for any meaningful purpose. And proponents of data localization believe that if data is oiled, whoever controls it has the power. They believe that data localization can help Indian government prevent foreign surveillances. Now you could understand how sensitive this term is. Accountability of entities processing personal data and remedies for unauthorized harmful processing, which is penalty, and to establish a data protecting authority. Now, what is data protecting authority? According to Sri Krishna Committee report, Data Protection Authority, its responsibility is to conduct an assessment and audits to make decision, and they have an adjudication wing where we can go and complain. Whereas the right to privacy is a fundamental right and it is necessary to protect personal data as an essential facet of informational privacy. So we have seen that privacy is not a choice and it should not be the price plate for our access to internet. With great advance in the technology field constitute a greater danger to the privacy of every individual. The growth of digital economy has expanded the use of data as a critical means of communication between person. Now, in the era of digitization, where information is the power and the data is the new goods of raw material in this digital economy. Before we could go the principles while framing the data protection law, we must need to have a quick understanding and a brief understanding of the history of right to privacy in India. So, the history of right to privacy started way back from 1954. Under these cases, we will study how the right to privacy became a fundamental right in Indian Constitution. So, MP Sharma versus Satish Chandra case in 1954, this was a case of Dalmia Group, where the investigation was done regarding the corruption in their balance sheet made by this Dalmia Group. So, search and seizure operation were conducted, in which Dalmia Group filed a writ petition that along with the official documents, their personal documents have also been unveiled by the government. So, then a bench of 8 judges in the Supreme Court gave decision that there is no concept of right to privacy in Indian Constitution. So, right to privacy got rejected in this case. Then in 1962, the Kharak Singh versus Uttar Pradesh, Kharak Singh was charged for dacoity case. Under that, UP police have put Kharak Singh on surveillance, in which suspect and domiciliary visit and tracking were ordered. So, again Kharak Singh filed a writ petition claiming that his fundamental right of movement and right to privacy has been violated. In that, a bench of 6 judges gave decision that there is no right to privacy guaranteed in a fundamental right. So, this bench has also rejected this right to privacy. Then in the case of People Union for Civil Liberty versus Union of India in the wiretapping case 1997. So, in this case, Supreme Court clarified that the right to privacy is guaranteed under Right to Life and Personal Liberty Article 21. So, but however, the condition of right to privacy, and there are so many cases have been violated against the right of privacy despite of this judgment as well. So, in Aadhaar case, Justice Puttaswamy versus Union of India, a bench of earlier there was a bench of 8 judges, 6 judges who have rejected. So, now there was a bench of 9 judges who gave a unanimous decision that Indian citizens do have right to privacy, and there is no separate declaration required to protect this right of privacy, as it is enshrined in Article 14, 19 and 21 of the Indian constitutions. So, in this Aadhaar case, there was a landmark judgment and the right to privacy then given to the citizen of India with this judgment. Now, let us have a comparison of the global models and approaches to data protection across the various countries of the world. Let us start with European model. Provides a comprehensive data and protection law for processing of personal data. As we know that in European Union, the right to privacy is a fundamental right which seeks to protect an individual's dignity. The European Charter of Fundamental Rights recognize the right to privacy as well the right to protection of personal data. And European Union poses a comprehensive data protection framework which applies to processing of personal data by means and to processing activities carried out by both the government as well as the private entities. Although there are certain exemptions in terms of national security, defense and public security. And if we look at the US model, in US the privacy protection is essentially a liberty protection, is that protection of the personal space from the government, like the government has no right to encroach in the privacy of the citizen. So, this is a very unique and important model. Unlike in European Union, there is no comprehensive set of privacy right. principles that collectively address the use, collection and disclosure of data in the US. Instead, there is a limited sector specific regulation. Second, the approach towards the data protection varies from public and as well as private sector. The activities and power of the government in personal information as well as defined and addressed by broad, sweeping legislation such as Privacy Act, the Electronic Communication Privacy Act, etc., etc. So, in a nutshell, we can make an inference that US model allows personal information, the collection of personal information, as long as the individual is informed of such collection and use. That means it also includes the consent of the individual. However, it has been viewed as an inadequate in respect of regulation. Whereas in European Union criticized for being excessively stringent and imposing an obligations on the organization processing data, like obligations on the fiduciary, the one who is collecting data, has been made and they have strict imposition on the obligations. But in case of India, as we have seen that while framing of the constitution, we try to have the balance of the both side of the coin. So, in this case it is advisable that India must find a right balance so as to take advantage of a data driven ecosystem with all reasonable restrictions. So, India may adopt a hybrid approach of the two model, considering India's potential to lead the world into digital economy, making use of its existing strength in information technology, demographic dividend and its need for empowerment based on data driven access to service and benefits. This threshold is a bit bigger as compared to the right to privacy, which is fundamental right of the Indian Constitution, which draws its power from the Supreme Court of India in its decision has held privacy fundamental right, and it believed that needs to be limited by reasonable restrictions. So, this threshold has to balanced with our ongoing digital economy of trillion-dollar economy. In India, the data protection regime must follow the 7 principles while framing the data protection law, which was laid down by the committee with a white paper and a draft bill 2018, which comprises of members from the civil society and human rights field. The first principle states that right to privacy should be non-negotiable towards protecting individuals' right. This is in accordance with the judgment in the Kuttaswamy case versus Union of India, in which right to privacy declared as a fundamental right. The law must apply to both state and non-state entities. Differently, obligations may occur based on security and critical issues, like companies or even government when they acquire our data, even sometimes in policy making, planning, and companies that make inference that they made through our data, they comply to what they are going to do with our data in terms of private policy in the purview of data protection bill. And next is enforced consent. Consent should be taken from the principal data relates, that is we the user, with citing reasons as to which purpose this data is going to be used. And this also includes the right to forgotten. Under this right to forgotten, that when the data is of no use, the user can ask the fiduciary to delete from the internet platform. The principal should be informed about of which purpose this data has been put to use. Fourth is data minimization. Data that is processed out to be minimal and necessary for the purpose of which such data is sought. We have often seen that sometimes unnecessary information of which it is not required for that particular business model has been collected from us. For example, when we log in, the fiduciary asks to the access of our media files, which is not of any purposes. Or when we go on to any shopping mall, they ask for our email ID or phone number. So when you are purchasing something of, like for example, if you are going to grocery shop, you go and buy your grocery, come back. In that, email and phone number is unnecessary. Data which is processed out to be minimal and necessary for the purpose of which data has been collecting. Controller accountability. Now the data controller should be held accountable for any processing of data, whether by itself or entity with whom it has been shared the data. So the accountability should be there, and if this accountability is violated, there should be extreme penalty. Only then we could curb or control or check the misuse or unauthorized use of our personal data. The data protection, there should be some data protection authority that has sufficient power, authority which must coexist with decentralized enforcement mechanism. The data protection agency, a body that would act as a regular hearer of grievances, monitor if the data bill was being flouted. Seventh is deterrence penalties. Penalty on wrongful processing must be adequate to ensure deterrence. This was all the basic framework that we need to, or we could say this is the this should be these 7 principles should be the preamble of our data protection bill. Now, as we have read in the clause of the preamble of the bill, which states that the data protection must be privileged over data economy interest. But according to Indian Freedom Foundation, India, which desperately needs a data protection legislation, especially considering the rush in which digital policies are being introduced in the country. But however, Data Protection Bill 2021, which should empower the user with rights surrounding their own personal information, has failed to prioritize the user. It instead benefits the government and way more than it benefits users. So now we will have a quick look as to why the government has withdrawn the data protection bill recently in the monsoon session on the basis of the joint parliamentary committee reports. So here it says that 2 years of deliberation and a few changes in its composition, the joint parliamentary committee on December gave this report, and this contained a new version of the law titled as the Data Protection Bill, instead Data Personal Protection Bill. Now we would see the reason that inclusion of non-personal data within the bill. One of the first recommendation of the JPC is to change the name of the bill from personal data protection to data protection, as according to JPC. It is impossible. Why it is saying? Because it is impossible to demarcate between personal and non-personal, and therefore is it important to have one single legislation dealing with both data set, that there should be one data which is counted, instead personal or non-personal. Now what is personal data and non-personal data? When the data is collected from us, it is divided into 2 sections. One is personal data and the second is non-personal data. So personal data, any data that uses to identify the users. For example, its identification information like name, address and sexuality. Whereas non-personal data it does not define the identity of a single individual. Rather, it is a sum or the aggregate in some form or a compiled data together, which could make a meaningful inference. For example, how many people are using TikTok, or which particular street has Uber traffic. So this data does not identify, but it is very handy. So what are the side effects of this non-personal data as well, which was the concern of JPC report, that has recognized that real possibility exists of identification and subsequent profiling of individual, that and from non-personal data and anonymous data. This I will explain regarding the side effect of anonymous data later, but let's understand that how non-personal data is used to make the profiling of the individuals. For example, as I have already explained, that sometimes FB asks your phone number, one for the authentication purpose and the second is to login purpose. Then the Facebook then transfer your mobile numbers to other third entity who can give you, on the basis of your profile on your of the profile, they can provide you targeted ads. So this personal data further divide into sensitive personal data and critical personal data. Now the sensitive personal data, this predetermined in this bill that includes information like health, financial and transgender status. So this predetermined list, the government can change this list the way they like. Also, the critical data, government has complete control in that it decide that what they deemed to be critical. The bill is silent in this, that which kind of data are critical personal data, and it depends upon the government on the time to time basis that they would change the norms at which kind of data comes under critical personal data. So the basic difference between all data, that any data collection requires consent from the principal data, that is the user. One important thing, which is again another term that has been used in this bill, which is called data localization. We need to understand the concept and the concern of the government regarding data localization. Data localization implies that certain data taken within India needs to be stored within India itself. They believe that data localization can help the Indian government prevent foreign surveillance. Now, the sensitive personal data can be collected in India but can be processed abroad given approval of the data personal authority. So, this sensitive personal data can be collected in India and can be processed approval of the data personal authority. But critical personal data cannot be stored or processed outside India, and this kind of data are generally military data or related to data related to security purpose. So now the bill is going to be important, that how the data is going to process, how they carry data, and how the consent that they need while collecting data. The important concern from the government point of view in this case, and it is very important, which I am going to tell you now. What's the government stand over this? If the Sri Krishnan policy would be too protectionist or it would be too strict regarding maintaining users' privacy, then as we know that India is booming in IT sector, which could be affected. Now this is the government's concern that IT sector would get affected as foreign business would vary, and there are certain startups, foreign startups, whose offices are there in India but they have their servers there in the foreign countries, and they don't have proper infrastructures to set up data storage facility there in India. They are likely to get withdrew from India. So this would be harder times both from Indian startup as well as for foreign entities. So certain data would be exempted. In this case, sensitive personal data can be processed outside. Certain exemptions are needed from the government and the regulator, but critical personal data has not been defined in this act as though. Now the second concerning point of the JPC committee, concern regarding the wide power and almost blanket exemption given to the Union government under clause 35 to exempt any government agency from the ambit of the bill continued and have further been cemented by the clause 35, which reads, nothing withstand anything contained in any law for the time being in force. The worst thing is, on the contrary, exemption unrestricted power has been provided to the Union government to frame policies for the digital economy. Clause 92(1) of the bill states, nothing in this act shall prevent the central government from framing any policy for the digital economy, including measures for its growth, security, integrity, prevention of misuse, and handling of non-personal data, including anonymous personal data. Now this point says that a power has been given to Union government to empower the different departments to frame policy, which could be contrary to the provision of the data protection law. Considering that the Union government is the custodian of a large data set of non-personal data sets across different sectors such as health, financial data, It is concerning that such a wide unrestricted power has been vested with them. So such clause also go against the assertion made by the JPC in its report and in the preamble of the bill, which is against the preamble of the bill, which states that the data protection must be privileged over data economic interest. The next concerning point is non-consensual processing of personal data. This is of utmost important point and a matter of concern. As per clause 12, the state does not need to conform to the consent principle if such processing of personal data is necessary for the state to provide. It is important to know that instead of diluting the provision and including the condition of proportionality and legitimate state aims for non-consensual processing of personal data, the bill has actually expanded the entities which can process personal data without consent. It now includes quasi-judicial authorities within such framework. And again further, the JPC has reported and highlight the power asymmetry between an employer and an employee, and had observed as the employer collects all the data of all the employee and there is a trust relationship between them, which committee thinks should be respected. Therefore, there should be an equilibrium in processing of data of employee and its misuse of data by the employer or the fiduciary. Now I will tell you why from the government point of view it is important. See, sometimes or it is always required that social media verification provision is needed. Now the government want to curb the spread of misinformation. But how can this verification affect us? Government believe that verifying the identity of user is going to help in tackling the spread of misinformation on the media platform. Now because of the digital illiteracy and reasoning, which news is true or false and the rate of velocity with which this misinformation spread on digital platform is a concerning issue for the government or for the law and order agencies to handle. So by verifying the user poses may privacy risk does not demonstrable help to fight take news information, but in another term this could be proved as a counterproductive for the whole purpose of this bill. This bill will actually force the user to verify by giving government identities. So these companies will then harvest and process the information to target users. Another thing, if the user do not verify or keep their identity disclosed, then their account would have to be reported to the government, and this is likely to be again another problematic because this makes government agency as well as law and order enforcement generally monitor the activities of such users or such account. So this would be a breach of right to expression and right to privacy, and often there are certain trade secrets and intellectual property rights that such the verification of the account is mandatory. Now next is the dilution of the power of the Data Protection Authority. An independent and robust data protection authority is the hallmark of a strong data protection regime. Unfortunately, the bill has, though its various iterations, continue to dilute the independence and power of the Data Protection Authority. Now how? Let's see. The 2018 bill had expressed and stated that the salaries, allowances and other terms and conditions of the services of the chairperson and other members of DPA would not be varied to their disadvantage during their term. This provision has been deleted under 2019 bill and thereby giving the union government the power to reduce their salary or amend in terms of appointment to the member of the DPA. Further, in 2019 bill, the DPA was bound by the orders of the central government on the questions of policy, with the central government also having the power to decide whether a question is one of policy or not. Unfortunately, under 2021 bill, the power of DPA have not been given, more diluted as per under clause 87(2) of the bill. But DPA will now bound be by the direction of the union government on all matters and not just on questions of policy. The last is The JPC and the bill recognize the importance of privacy and need to protect all facets of data. However, unfortunately, this is only for the private actors. The expansion of the scope of the encroachment of privacy by the government actors continues, and accountability of the state in protecting our privacy continued to elude us. Now, in this case, the government should be the highest accountable authority in our data protection regime. So, again this has negated the principle of right to privacy in this data protection bill. So, again this clause has raised a red flag against the government surveillance. So, this was all about the brief history and overall framework, why there is an utmost need of the data protection bill. I have tried my best to make your concept clear. I hope you found this video informative. Please like and subscribe my channel. Thank you so much.